Good afternoon, ladies and gentlemen. Thank you for joining Mediation webinar, jointly hosted by Singapore International Media Center and Korean Commercial Arbitration Board International. I'm Hywan Kwon, Director of KCAB International, in charge of international cooperation. Well, actually, as we were out, the disruption arising out of the COVID-19 pandemic are unprecedented, definitely unexpected. As disruption gave rise to dispute, what can ADR institution could help or assist our client? Through just a conventional way, such as arbitration? Yes, definitely. We have to upgrade our quality through just the new normal. But however, let's think about just a new way, more efficient, more amicable, more innovative, such as international mediation. So we got just very just good support, such as the Singapore Convention. So this is time we really think about just the importance and the opportunity of international mediation for resolving our dispute. So this seminar has been designed and created for providing more insightful way to our client for seeking this alternative way rather than litigation and arbitration. So I would like to introduce Professor Hi-Taek Shin, Chairman of KCAB International, for delivering his welcome remarks on behalf of two institutions. Professor Hi-Taek Shin is the Chairman of KCAB International, Korean Commercial Arbitration Board's International Division. He also serves as the governing board member of International Council for Commercial Arbitration, ICCA, named ICA. Without further ado, I would like to invite Professor Hi-Taek Shin. 회장님.
Thank you very much for the good and kind introduction. On behalf of KCAB International, I would like to thank our speakers and audiences for participating in today's webinar on the topic of future of international mediation, post-COVID-19 pandemic, and its impact on cross-border disputes. Today's topic is very timely. I think you will agree. COVID-19 pandemic has caused very substantial disruptions on almost all commercial and contractual relationships on the global and local economic scenes. The losses caused by the pandemic need to be borne by someone involved in the transaction, unless such losses are covered by taxpayers' money. Inevitably, we will see tsunami of disputes, if I can borrow George Lim's words in his presentation later today. How to resolve the tsunami of disputes is a challenge for the business community, as well as our profession involved in the dispute resolution. Furthermore, as the current pandemic crisis does not show any sign of going away easily, uncertainty would continue for the foreseeable future. Should COVID-19 eventually become a fact of life, unfortunately, how we deal with the risk and repercussions from it remains another critical issue. Given that the typical nature of potential disputes caused by this pandemic is that no one could be blamed for intentional non-performance, delay, or negligence, mediation could be viewed as the most appropriate method of resolving this type of disputes. Unlike traditional litigation or arbitration, where winners and losers are starkly contrasted, mediation aims to bring the parties together to a mutually agreed resolution. The beauty of mediation is that the business relationship could be maintained or restored without hard feelings. Fortunately, we now have Singapore Convention in place, which will become effective in September this year, thanks to the remarkable efforts of our dear friends at SIMC. On behalf of KCAB International, I am very pleased to organize this webinar with SIMC, the recognized front runner in the field of international mediation, with the personal participation of our dear friends George Lim and Chuan Meng. I also appreciate Kevin Kim and Byung-Woo for their valuable contribution today. On its part, KCAB has its own set of mediation rules and annually administers more than 1,000 court-annexed mediation cases. Last year, we signed an MOU with SIMC on the occasion of the Singapore Convention signing ceremony in Singapore in August. KCAB has been exploring ways to develop international mediation rules better tailored to meet the growing needs of the business community for mediation services. We sincerely ask for your continued support for our endeavor to enhance our mediation services. I trust that today's webinar will present the virtue of international mediation as the most efficient and desirable dispute resolution method in the post-COVID-19 era. I wish that I could meet all of you in person as quickly as possible. Until then, stay safe and healthy in these turbulent and uncertain times. Thank you very much.
Thank you, Professor Shin. I truly appreciate your insightful comment on the current status and the future of mediation. So let's move on to our moderator, Mr. Kevin Kim. Well, actually, this morning, I asked his assistant to provide his short bio, but however, I got 5 pages from his bio. Probably his assistant think maybe 5 is quite short to describe himself. Anyway, I believe probably 99% of audience attending to this webinar is familiar with Mr. Kevin Kim. So without further ado, I will invite Mr. Kevin Kim as today's moderator. Kim 변호사님.
Professor Shin, and I thank KCAB and SIMC for organizing this webinar. We luckily have 3 very prominent speakers, panelists today to cover various issues. The first speaker I will introduce is Mr. Byung-Woo, which is quite challenging pronunciation even for Koreans. So I'll call him just BW. BW is a partner of Kim and Chang's international arbitration cross-border litigation practice. He has a variety of experience in all different areas. He is absolutely star individual in the arbitration and other dispute resolution area. And our next speaker is Mr. George Lim. I would describe him as the father of international mediation in Asia. He is all sorts of energy and the ideas. are always amazed by his ability to make things new and even better. So he said as the mediator, he very successful. I heard that his successful ratios almost reaching to 90% of success in the mediation. So we will hear from him about what will happens in the mediation in the future. The next speaker is Mr. Chuan Meng. Meng is actually doing now is a model job in the SIMC together with George Lim. But he was the lawyer in the big law firm in Singapore, and then he moved to IBM, the China, the general counsel, and then we're lucky to have him as the CEO of the SIMC. So without further ado, I would invite Mr. Im, BW, speak about new challenges in post-COVID-19 era for business. Mr. Im?
Thank you, Kevin. I'm Byung-Woo, a partner of Kim and-jung's International Arbitration Team. It is my honor to be a part of this webinar together with renowned moderator, and the speakers. For today, I was asked to discuss challenges and difficulties in international business arising from COVID-19 and the ways for dealing with those problems, particularly from dispute resolution perspective. To be short, COVID-19 will cause many disputes, but most of them might not be appropriate to be resolved by traditional ways of litigation or arbitration, as Dr. Shin commented at the beginning of this webinar. For those COVID-19 disputes, mediation will be better dispute resolution method, particularly if handled by experienced mediator. So let's start from page 1. As all of you are well aware and experiencing, COVID-19 has made our personal life difficult. Social distancing, self-quarantine, travel ban, and even going to lockdown of entire society. This results in serious economic downturn. Thus, every business is suffering delay, suspension, termination, and naturally, many disputes are arising. From arbitration or mediation perspective, I think the following industries or business sectors are particularly relevant. First, large-scale business such as construction or energy project. As you understand, in those projects, the multiple dispute among various participants may arise. Second, the risk of dispute will be higher in business based on long-term relationship, such as long-term supply agreement, joint venture agreement, distribution agreement. Also, the business based on the long-term market prospect will be likely more impacted by COVID-19, such as M&A transactions. The needless to say, due to the travel bans, most of the international businesses, like the exporting and importing, they are severely affected by COVID-19. In fact, our office are getting more and more questions and issues from the various clients, particularly in these business sectors. Next page. It would be good if those disputes from COVID-19 are smoothly resolved by contract or applicable laws. So these days, there are a lot of discussions and webinars on the meaning and implication of a force majeure clause, suspension clause, or what is material adverse change, allowing the parties renegotiation of the contract. Or there are special laws or regulations to address the problems from COVID-19, but those laws might not be sufficient for dealing with every complex matters from the COVID-19 situation. There are also legal principles protecting parties from the very severe situation, like the principle of change of circumstances, or frustration and hardship. However, it is generally understood those contractual provisions, arrangement, or the special laws would not be sufficient to be effectively resolved all of the commercial issues arising from the COVID-19 due to their limitation by their nature. First, the threshold of a requirement of those solutions are generally high. For instance, for force majeure, in most cases, it is required to establish the performance of the obligation was prevented. And generally, it is difficult to say that in case of a delay, it should be deemed as a prevention. The delay in most cases cannot be deemed as prevention. So force majeure clause in many cases difficult to be used for the protection from the COVID-19. Likewise, the principle of change of circumstances, the threshold is quite high. For instance, it is well known in Korea that there is a case law that the increase of the raw material prices in IMF crisis times, more than several times than the past, should not be deemed as satisfying the requirement for change of circumstances. So the laws and contract provisions might not be difficult to protect the parties from the impact from COVID-19. Also, from legal and practical perspective, it would be difficult to establish in many cases the causation between failure to perform and COVID-19 situation, because in many cases, self-quarantine or even lockdown does not mean that impossible to work, because we can work by internet and have a discussion by technical method like this webinar. Also, the accurate quantification of damages from COVID-19 should be challenging, and as we are aware, very costly. So please click. All of these factors make it difficult to resolve COVID-19 dispute by traditional ways. More importantly, every business and everyone in society suffers difficulties due to COVID-19. It would be more important to find out reasonable compromising ways to maintain business relationship and protecting society altogether. Next page. Among various dispute resolution methods, amicable settlement might be the best way to handle this difficult situation. However, as discussed, everyone in the society suffering difficulties, it would be very difficult for them reaching on compromise or settlement voluntarily. So they need some help. However, as Dr. Shin said, also Kevin said, the traditional court system or traditional arbitration might not work well. So particularly in case of a traditional court system, after COVID-19 pandemic, we are experiencing suspension or delay in court procedure, which shows that it takes time for the traditional system to be accommodated for the resolving various issues. For the large project or large dispute, arbitration might be a way to resolving the dispute, but as many people agree, it is very costly, so might not be a good solution for that in every case. Therefore, the importance of mediation as a more efficient and creative dispute resolution method should be highlighted, particularly for international business and international dispute. So this is the end of my brief introduction, and we will hear more details and the merit of international mediation from the speaker, and I hand over from now to Kevin for the next session. Thank you.
Thank you, PW. Yes, thank you for sharing your insight and experience. Now we hear from Chairman of SIMC, George Rim. As I describe him as a father of international mediation in Asia. He now say this is the right time for the mediation. So George.
Okay, thank you, Kevin. Annyeonghaseyo. And thank you very much to Professor Shin, Mr. Chuan, and KCAB for helping us to co-organize this webinar, KCAB and SIMC. You know, we have reached an understanding that we would work together. And I think this is the first of many ventures that we will be collaborating on. I have a close affiliation to Korea. You know, some of you will know my son did his master's for 2 years at SNU. So he can speak and he can write Korean. And of course, you know, my wife watches Korean drama every night. So for me, Korea is special. Yeah. I'm here to share with you about the state of international mediation. I think pre-COVID and post-COVID. So I'm going to need some help from Ji-Yoon, who's going to help me with some slides. Right, next slide, please. Next slide, Ji-Yoon. Yes, so for those of you who do not know about SIMC, we are a not-for-profit organization. We are very young. We were formed in November 2014. And we promote mediation, the mediation of cross-border disputes all over the world. Okay, next slide. Yeah. I'm just going to be very quick about this, just an introduction. Next slide. Yeah, so we have a panel of mediators. There are 70 plus mediators from all over the world, not just Singapore. We have tried to select the best mediators in the world, and we are present in 17 jurisdictions. Okay, next slide. I'm now going to try and show you the growth of mediation, particularly in Asia, because we have been active in Korea, in Japan, in China, India, but a very quick snapshot of what's happening. And one of the countries that has really embraced mediation, I can tell you, is India, because India for many years, you know, India is large. It's 1.3 billion people. They have been trying to promote mediation. But I will tell you that in the last few years, it has really taken off. And you can see here some photographs of mediation training, which we've done in India with judges, ex-judges, very senior lawyers. And I can tell you now that they are really interested in mediation. Yes, next slide. So in February this year, just before COVID broke out in a large way, I was at an arbitration conference in New Delhi, okay? And the guest speaker was the Chief Justice. And you see here his face in that press article. And you know, at an arbitration conference, here he is, he's talking about mediation. And he's talking about compulsory pre-litigation mediation. So that's how far they have gone to. You see that photograph of me standing up with the man on my, well, to your right now, that's Mr. Sriram Panchu, and he's the father of mediation in India. And he helped to help mediate that temple dispute, you know, that India had. So this is really happening in India, and I can tell you that they are all now keen on mediation. Next slide. Japan also, you know, Japan set up an international mediation center. That photo of three of us, you see the man on my left, on your right, Mr. Akira Kawamura. He is the former president of the IBA, and he's now on our panel, and he's also very interested in promoting mediation in Japan. Next slide. Yeah, China. China is big on mediation now. I think you know, Korea, you're close to Chinese business people, and you know that they are also into this. We have signed an MOU with CCPIT Mediation Center. This is in Beijing, where we're going to handle Belt and Road disputes with them. Okay, and next slide. Now, of course, next slide. Not forgetting Korea. Okay, so some of you know we have been working with many of you, promoting mediation, doing training, having seminars, and today the webinar. So I'm told by Kevin that I think Koreans are now ready for mediation, and I really hope that this can be a thing which is part of your dispute resolution scene. Okay, and we want to work together with KCAB on this. So this is just to give you a snapshot of what's happening just in 4 countries, okay? But all over the world, mediation is taking off. Yes, next slide. And I want to tell you why, because just let me share with you a mediation which I did recently. So this, I can't go into the details, but I'll tell you about the case in general. There was a mediation between a company, it's a global lifestyle company. If I tell you the name, you'll know it, which had a factory in an Asian country. Let's call it country X. And they found out that they had a lot of their products were leaked, L-E-A-K-E-D, okay? They couldn't account for many of their products and they suspected something wrong was going on. And then they found that somebody in Singapore, okay, was actually a foreign national in Singapore, was selling their products online, okay, without permission, without proper authority. So they sued that party in Singapore, and for a lot of money, for a lot of damages because of the damage that it caused to them. But this person was an individual. This was the only person they could catch in Singapore. They filed police report, but they came for mediation. And it was a difficult mediation because this guy obviously didn't have a lot of money. He was trying to make a buck, a quick buck. But in the course of the mediation, the plaintiffs, the lifestyle company, we found out through the private sessions that their interest was really to find out what was happening in country X. Why were their products being leaked? Okay. And in the end, we managed to settle it in a day. And I will tell you the terms of the settlement. If we go back to the slide, Jiun. It was the next slide. Next slide. Yeah. So in the end, the breakthrough came because we managed to persuade that individual in Singapore to help the lifestyle company with their investigations in country X. That was the big fish was there. Okay, so they were really interested in trying to find out what was happening to their products, and that cooperation turned the deal. Okay, and of course the individual in Singapore agreed to pay a certain sum, but over years by installments because he didn't have the means. So this is an example of what's happening. I mean, many disputes all over the world, but something like that, which can be settled, in a day, and to the satisfaction of both parties. And with respect, I will say that, look, this is something which would have been difficult to achieve in court or in arbitration, because this meant in the end, the two parties coming together and trying to understand their interests and working out a solution which helped both of them. Okay, and I think most of you, those of you who are lawyers, who are arbitrators, who are mediators, you will know that there are many disputes around the world which can be resolved. Next slide. So just by way of example, at SIMC itself, and we're just talking cross-border disputes, international mediations, we've had 108 cases. It's not a lot, but it is a good start because it's not that easy to get people to come and mediate their cases, international cases. But we've been doing this, and we do this in Singapore and all over the world because the mediation can be held anywhere. Total dispute value, 3.6 billion, and our average settlement rate is about 80%. And you see there in that pie chart, the countries who are involved, the parties from the various countries who have been involved. So quick snapshot before COVID really happened. we can see the growth of international mediation through what's happening in the various countries and the caseload that we've gotten in SIMC. So now I'm going to try and move on to post-COVID, COVID and post-COVID, because you've asked me to take the crystal ball and look at it and see what's going to happen in the future. Okay, so post-COVID, next slide, please. Yes, next slide. So you've heard this word tsunami, right? And Professor Shin, I think we all agree, there will be a tsunami of disputes. There will be plenty of disputes. BW talked about this as well. We talked about construction cases, infrastructure cases, energy cases, M&A cases. I think we all know that once the dust settles, people will be looking at how to better their positions, and there will be many disputes. And I'll just give a very simple example, right? On Monday, I went for a haircut, okay, with my barber to prepare for this webinar. And he asked me for advice. He said he owns a property and his tenant is not paying him rent, okay? And he's got to pay his mortgage. And he said, what to do? So something so simple like this, but people are really in financial difficulties now because many businesses cannot operate at that full level. And so people are financially strapped. So there will be many disputes coming on. Next slide. Okay, and for me, this is actually an opportunity for there to be more mediations. I think this is a light scenario. Not that we want to have mediations, but there are disputes. And I think mediation is a good way to help them resolve the disputes. Okay, so more disputes, more mediations. Next slide. Okay, so this is a thing now that's happening, right? The new norm, online mediation. So this is also happening in Singapore, I think all over the world. I spoke with one mediator in America, in the US. She helps to run jams, and she said jams has had 1,000 odd online mediations in the past 4 to 6 weeks. Okay, because people cannot travel and there are disputes to be resolved. And in fact, I'm doing a mediation next week with SIMC, where it will be done partially online, because the parties who cannot fly in will be doing it online with us. So online mediation is a new area. Okay, it's not that new, but I think now the focus is on online mediation, and it's not the same because you do need different techniques and different skills if you're a mediator. And even as lawyers representing parties in an online mediation, okay? It's not face-to-face, so how do you reach out to people? How do you get people to talk? How do you try and find out people's interests? How do you build rapport and then try and get an outcome, which is good for all parties? So this is the third thing I say which will be happening, online mediation. And at SIMC, we are going big on this. Meng will explain later on. We've set up a COVID-19 protocol, and it will be online. Yeah. Next slide. Okay, this is a trend which was happening pre-COVID, but I think this will continue to happen, that parties will look for hybrid processes to resolve their disputes. And what do I mean? I mean a combination of mediation, arbitration, neutral evaluation, so different processes. I think this is going to be the thing for the future. So for example, I'm going to go quickly now. Next slide. Next slide, please. So at SIMC, you know, we are a sister company of SIAC. Some of you are familiar with SIAC. We have an MEDAP protocol. Okay, a one-stop process where people in arbitration can mediate. And if they resolve the matter is converted into an award. It is enforceable all over the world under the New York Convention. If it's not settled, it goes back to arbitration. So this provides a sure way for business people to get an outcome. And we've had increasing use of the AME protocol at SIMC. Okay, next. Next slide. So I'm told that in Korea, there is a lot of interest in investor-state disputes. I have been attending the sessions at Untitled in New York and Vienna. Korea is represented, I think Professor Lee Jae-im is there on your behalf. And you know, right now, the investor-state disputes most of them go to ICSID. But there has been a lot of criticism about the current process, and that the working group, this working group at Untitled, which consists of 107 states, they are now advocating a permanent court, okay, with an appellate procedure and with mediation. We're talking about how mediation can play a part to help investor-state disputes. So you find this combination of hybrid processes again, and I think mediation will become very popular in investor-state disputes. Okay, next slide, please. Yeah, enforceability will become an important consideration because it's cross-border for obvious reasons. Next slide. Yeah, and this is where I come onto the Singapore Convention on Mediation. And if you see my virtual background, that is actually a forum which we held at the Singapore Convention in August last year. So the convention now, you know, for those who don't know, it helps parties who sign on to have international mediated settlements enforceable in the various countries. To date, we have 52 countries who have signed, okay, which is a record. And Korea has signed, China has signed, India has signed, US has signed, and I tell people that's more than half the world's population, okay? 4 countries have now ratified the convention. You only need 3 to bring it alive. So Singapore, Qatar, Fiji, and Saudi Arabia recently. Okay, Belarus has said it would be ratifying very soon. So we're going to have 5 countries soon. We hope Korea would ratify very soon too, because I think the more countries that come on board, the better. And this will make international mediation really a dispute resolution form which businessmen will really look seriously at and use it. Okay. Next slide. So for me, if you ask me one message today, I'll tell you the growth and increasing use of mediation is unstoppable. That word I got from a forum in India in February. The crowd, the audience would say it's unstoppable. Okay. Yes, next slide. So this is my message to lawyers, to arbitrators, to mediators, all right? Those of us who can offer a suite of services, we will have an advantage in the future. That is a sure thing, okay? Because all over the world now, parties, business people, they are not interested in having long drawn out battles. Seriously, they want their problem solved quickly. Okay, and to me, if you can offer mediation, you have an advantage. Of course, if the matter cannot be resolved, then you go for arbitration or litigation. But at least we offer the clients the best way to resolve their disputes. Okay, and Koreans, I know you are coming on board. There are some of you who have come for training with us. I would encourage you all to come for mediation training with KCAB, with SIMC. Yeah. Okay, I want to end off with something very quick, just without the slides, June. And thank you, Kevin, for giving me time. For me, you know, COVID-19 is not just any disease. It's something unprecedented. You know, in the last few months, the world has been turned upside down. You know it, I know it. So for me, it will spawn many disputes, okay? And the best way to resolve these disputes is through mediation. Because we need to understand. I mean, there are many people who are in a particular difficulty in a dispute, not because of their fault, not through their fault, because of something which has happened. So I think we need to be more understanding. We need to be more compassionate, not just fight or not just, you know, assert all our rights, even if we are entitled to legal rights. In the end, the guy may not be able to pay. So for me, this is a time for more understanding, for more compassion. I tell people, you either fight it out or you try and talk it out. And to me, the better way, the more Asian way is to talk it out. So thank you for listening to me. Thank you, Kevin, for giving me time. And you, there are 125 of you out there, thank you for taking this afternoon to listen to us.
Okay, thank you, George. Now we are going to hear from Meng about this SIMC COVID-19 protocol. This is more like online dispute mechanism, and that protocol we proceed mediation. Meng?
Thank you, Kevin. It's wonderful to be here with such a distinguished panel. And Kevin, I mentioned to you earlier, I was admiring this beautiful backdrop that you have, and it reminds me of the wonderful time we had in Seoul last year. And George was showing the photograph of the lunch we had with the specialist mediators. It was September of 2019, and it just seemed, so long ago. And it's really wonderful to be able to connect with our Korean friends and with KCAB. So thank you once again to KCAB for hosting this. We are very privileged to be able to do this with you. Thank you. Now, if we may go to the slide. Okay, so the first slide that we have, resolving cross-border disputes online. So a little bit of a background on this COVID-19 protocol. Obviously, Singapore was caught up very much in this whole COVID-19, and we were in lockdown. And one of the things that I keep hearing in many of my engagement with our overseas partners, including our friends from Korea, law firms, Kim and Chang definitely was one of them, KCAB as well, other law firms as well, Kevin, when we talked about it. And also other countries, George mentioned India, China, Japan, and communicating with our local senior lawyers as well. There was a great need that, hey, we need to get a better way of resolving disputes quickly and more in a more cheap, in a less expensive way and online, because there's a great need. You've heard from all the speakers about how there's going to be a tsunami of disputes. So we came up with this protocol really to help the parties as a service to community, as a service to businesses. And by doing this, everybody takes a cut from the fees. So whether it's SIMC, whether it's a mediator, whether it's Maxwell, we are holding it in Maxwell, everybody takes a cut from our fees, a discount, because we believe that this is something that is good for the community. So this is what we came up with, and I was hoping that it will be useful to some of you, and we'll be very happy to work with KCAB to see how we can work together on this protocol. So what is this protocol? If we move to the next slide. So this protocol is really an opportunity to allow parties and businesses to have an expedited, economical, and effective way of resolving the cross-border disputes, right? So we'll go through each aspect of it. Expedited. Why is it expedited? Because when we file the case, it's online, so there's no need for exchange of email, submission of documents, it's online. We commit to organize a mediation in 10 days in order for the parties to very quickly come to a resolution. We are also committing to do the entire mediation online if that's the preference of the party. In Singapore, we are starting now face-to-face meetings. That's allowed for mediation right now, but we do see that with travel restriction, it's still very difficult for parties to travel. And therefore, this online mediation will take out this cost of travel, the time for travel, and therefore we believe that this can be done very quickly to have the parties meet up, have the mediators appointed, and have the mediation done quickly, the matter resolved quickly. That's expedition, right? Very fast. Secondly is economical. Now, when I'll go into a bit of the rates later. We have a special chart just for that. But as I've said, These are special rates that we have committed. And what's more important is that not only is it a special rate, it is also capped at a certain amount, because we understand that when parties want to commit to a dispute resolution, it would be best if they know what is the maximum that they will need to pay. And we understand that. And we made the structure, the payment structure very simple, only 3 categories, and they are all capped at the 3 categories. I'll go into that in a bit more detail. It's also effective. Why is it effective? Because we are able to match the right mediator, the experienced mediator in the special field, with the particular issue and dispute that arise. So BW, you talk about construction, you talk about energy, you talk about infrastructure. We have mediators who will be able to support you with that, KCAB as well, and we can work together to find the best mediator for that particular dispute. And because it's online, it's very important for us to have online support for the entire process. A mediation is a little bit more complex than, say, holding a webinar, because you have breakout rooms, you have private sessions, you have a lot of drafting that has to be done online. So a lot of online support is needed, and SIMC is committed to providing online support before, during, and after the mediation itself. So it's a full end-to-end support. And of course, enforceability, George mentioned that as well. With the mediation, first of all, it's enforceable under the Singapore Mediation Act, and likewise also under the Singapore Convention itself. So it's a quick resolution to help protect business, protect the business's profits, and more importantly, the relationship as a result of that. Next slide. Why does it matter? I won't go into too much detail on this because I think the other speakers have talked about it. The important thing is that COVID-19 has impacted all the businesses, communities. The relationships are frayed, they are under threat, they are leading to disputes. What do the businesses want? Businesses actually want to be able to resume the operation quickly and not caught in lengthy legal actions, whether it's by arbitration or by litigation. They want a quick solution so that they can move on to focus on making more money to help their businesses. And we believe that companies that actually settle their cases will be in a stronger position coming out of COVID-19 pandemic, because they would have resolved this problem, they can move on, compared to other companies who may not be in the same position, still caught in legal disputes. Next slide. Next slide. I'm going to spend a bit of time on this because I believe it's important for us to understand how the COVID-19 protocol works. There are actually 4 steps to it, and I'll go into a bit of detail with each one in the next slide. But for this slide, I just want you to see how it works. You start with filing, and then you have a pre-mediation preparation, which is a lot of work, and I'll go into that in a bit of detail. The actual mediation itself, which can be online, or it can be face-to-face, or it can be partial online, partial face-to-face. So it's very flexible. And then there's a whole lot of post-mediation work that needs to be done. So next slide. Okay, so the filing fee, like I say, is very economical. It's inexpensive. It's only $250 online. And what I understand is $250 is about 22,000 Korean won, I believe. So that's actually a very small amount in order to register the case. After that, SIMC will then go into a series of actions: selection of mediator, speaking to the parties, getting the parties to exchange documents online, preparation of the mediator, very important to make sure that the mediator is prepared for the online mediation, and then separately, preparation of the counsel and parties. Right? So these are different preparatory steps that we take. We have a very detailed process that we go through with them. And then the pre-mediation conferences where the mediator will meet up with parties online to discuss any issues that they want to talk about before the actual mediation itself. And in step 3 itself is the actual mediation, which may or may not take place over one day. More likely it will take place over several sessions where the parties will meet, have the joint session, agree on the agenda, agree on the issues, have the opening statements, and then they'll go into private caucuses. So with the private caucuses is where we have private breakout rooms. Again, this can take over several days in small bites so that the parties can really fully focus, because online it's just harder to communicate and harder to focus compared to being in person there. And then SIMC will be there throughout the entire process to ensure that there's security of the mediation itself, to ensure that the people who are in the room are supposed to be there. There's no hacking, there's no uninvited guests, because that's very important. The confidentiality and the sacrosanct nature of the private sessions has to be protected. And then after assume that the matter gets resolved, we go into the post-mediation, which is the drafting of the agreement. We've got to settle, we've got to agree how that's done. We've got to prepare the e-signature so that everything can be done on the day itself when it ends. We've got to agree on the repository of the agreements because they are all e-documents. And then any follow-up action to be taken, whether it is settled, not settled, partial settlement, etc. So there's again a whole list of things that we will do. As you can see, there are 4 steps, but in each step, SIMC is very involved in every step of the way. And of course, this is just a very high level explanation of how the online protocol 19 works. But I hope that this will give you at least a picture of how it will take place from the online filing all the way to the end. Now, my last slide. This is the fee structure that we have put in place. You will see that, again, I talked about 3 categories where the dispute is below $1 million Singapore dollars, and I think that's about 870 million Korean won. The fee is capped only at $3,000 per party, which is about 2.6 million Korean won. Not a lot of money, right, per party. If the dispute value is from 1 to 5 million, again, 6,005 or 0.3% of the dispute value. And if it's above 5 million, then it's 10,000. And I think for anything that's above 5 million, which is about 4.3 billion Korean won, the fees are capped at 8.7 million Korean won, which is really not a very large amount of money. So what we've done is we've kept it very simple, 3 simple categories, and capped fees in each category to ensure that the parties understand what they need to pay and no more. And this is all inclusive of the mediator fees, SIMC fees, everything is inclusive. So as you can see, these are very attractive pricing to help parties to resolve the issue itself. So that's all I have for the COVID-19. And I would echo Professor Shin's words. I really look forward to seeing all of you, hopefully at the Seoul ADR Festival in November. And we will see each one of you, both the panelists as well as the participants in person. So, 안녕하세요.
Thank you. Thank you, Meng. Now I re-invite Byung-Woo to introduce a bit about Seoul Protocol video conferencing. I have personal affection to this protocol because this was made in a session when I moderate from London at 3 a.m. in the morning. That was 11 a.m. in Seoul during the Seoul Arbitration Festival. So, Mr. Lim?
Yes, thank you, Kevin. And I was allowed only 2 minutes for this discussion. So I just want to share our team's listened to experience in the virtual hearing in arbitration under the Seoul Protocol. And I should say the virtual hearing went well, and based on the guidelines from Seoul Protocol and discussion between the parties. And as mediation is less confrontational than the arbitration, I also believe this method will work well or work better for mediation. And there are several observations. It is not a very big issues, but several observations I would like to share with you. First, for the virtual hearing or virtual conference, the venues of the virtual hearing is very important. So in our case, the main hearing venue was KCAB, and the arbitrator joins from London and Hong Kong. So all the places with a well-developed internet network. So the hearing went well, but in case of developing countries, it might need to see whether it will go well like this case. And we did 2 times of test runs with everybody, and that was helpful for the smooth operation of the hearing as guided by the Seoul protocol. So importance of test run should be highlighted. And the translation, rather than the simultaneous translation, the consecutive ones would be more important and helpful for the virtual hearing. And in case of a virtual cross-examination, it went better than I expected. Particularly the face of the witnesses are closed, so their impressions can be captured by arbitrators and counsels by being monitored. But in case of some witnesses, they are not familiar with video and monitor. So before the virtual hearing and virtual cross-examination, preparation for being familiarized with this kind of monitor and the video things would be necessary, not a really factual or very detailed cross-examination for the preparing all issues. And it would be helpful for the participants, particularly counsels and arbitrators have more experience and the familiarity with electronic bundles. It is useful, but it looks like I personally had more many things to learn more. These are my observations and end of my discussion in this brief issue. Thank you.
Thank you very much. So when we discussed about Seoul Protocol in 2018, nobody is interested in the video conferencing very much. Now everybody became quite interested in this. It's quite an interesting development. So we have some questions already proposed. I see that the first question was proposed to the BWM about the advantage of mediation over adjudication. I think that anybody can answer to the question, but Mr. Im, you want to answer the question? Adjudication may deliver the similar benefit. So what will be the advantage of mediation over adjudication?
Thank you. And I think the question goes to the very merit of mediation. I believe that George is much better positioned to answer the question, but I start with my brief, my view, personal views, that in Korea, adjudication is not very widely used, but based on my understanding of adjudication in other jurisdictions like the United Kingdom, adjudication has some mandatory nature. So the adjudicator make a binding decision despite what the party's opinion or position are. And after the adjudication, since it is binding, there are a good possibility that certain party or both party are disappointed by the result. On the other hand, the mediation, if I understand correctly, is the process of assisting parties reaching a voluntary agreement, voluntary settlement agreement. So if I understand correctly, after mediation, even though the mediators, a final word, not a really decision, but the kind of recommendation, if accepted by the parties, then it is a good compromise, and usually there remain no parties, no disappointing parties after the mediation resulting in the reaching an agreement. And I ask George to confirm my understanding is correct with a better wording and explanation.
Okay, before the George answer the question, I add one more question, which was actually proposed to the George to answer. The other question is the settlement, the mediation, basically kind of settlement agreements. So that is supposed to be voluntarily enforced, performed. So why the enforcement that important? That is the question. So George, could you answer those two questions?
Okay, I think PW, you've got it there. I think there is a difference between mediation and adjudication or arbitration. Okay, and the benefit, of course, is mediation can be done quickly. It's less costly, but more importantly, you can try and preserve the relationship between the parties. It can also be creative in that the outcome need not be strictly according to the rights in a particular document. So parties can be creative. They can agree on something else as long as it's not illegal. And we call that enlarging the pie. So for example, you sue a director for breach of his duties and you sue for damages, but he's also a shareholder. And when people come for mediation, I say, why don't one party buy the other party out? You know, because you obviously cannot get along. Even if you succeed in arbitration or in litigation, he's still your shareholder. What are you going to do? You're stuck. So I tell parties, you know, come and mediate, and maybe you can find a way to go your separate ways in a nice way. So the whole day, the mediation is focused on the price, on what's a fair price. So that's an example. And in the end, you know, parties are happier. So it's like a divorce, but on amicable terms. Second question, is it, Kevin? On enforcement? So
why enforcement is important in case of mediation? The mediation, basically kind of settlement agreement, so the party is supposed to voluntarily perform the obligation.
Okay, so I think for those of us who have been mediating, if you structure a good settlement agreement, which the parties understand and can comply with, enforceability is usually not a problem in real life, okay? But we know that when we ask parties, when we try and persuade parties to mediate, usually they will ask you, if the other party does not comply, can I enforce it? Okay, and if you say, no, you can't, then they say, what's the point? I'm not going to mediate. So when you have the possibility of enforcing the agreement, I think it gives the agreement teeth, and parties, you bring parties to the table. You encourage parties to mediate. So I think that is the value of having enforceability. Whether or not it should be an award, under the Singapore Convention, if you have a settlement agreement which falls under the convention, you don't have to convert it, okay? If you want to enforce it in country X, you go there, you go to their courts, and as long as you can fulfill the criteria in the convention, it becomes enforceable. It does not have to be converted to an award, like in an arbitration. You just take the settlement agreement and you ask the court to help you enforce that, okay? Many countries have their own mediation acts. So in Singapore, in the same way with a mediation settlement, I can go to a Singapore court, and if I fulfill the terms, the court will help me enforce it. I don't have to start new proceedings. So in different parts of the world, this is already happening. But we all recognize that for business people, they want to have that possibility to be able to enforce in case something goes wrong. Kevin, does it answer the question?
Okay, thank you very much. We are getting more questions. Maybe
okay,
may I invite Meng on the question? This is more like online or virtual hearing thing. I think this is a more question about arbitration, but the same apply to mediation. if one party does not agree the virtual hearing delayed proceedings, the tribunal order to take place in about virtual the hearing. So maybe what about the mediation? Could mediator order or just decide to take the virtual hearing?
Thank you. That's a great question, because we are getting requests for online hearing, and we do have parties that are not sure. And in fact, we probably have our first COVID-19 protocol case, hopefully this week, that will come in. So this is an important question. In mediation, as you know, it's about party autonomy. Parties must agree. So if they cannot agree to an online mediation, we have to find out why. Why is it that they don't agree? Is it because they're concerned about security? They're concerned about time? Maybe they say, oh, you know, one is in the US, one is in Korea. Time may not be difficult to find the right time slot. So we have to really understand why the concerns are. And that's where SIMC and KCAB can come in to try to explore with the parties. Sometimes there can be a partial mediation. So like the one that George mentioned, the counsels are physically in Maxwell for the hearing. The parties themselves being overseas cannot fly in. They will hold it online. So I think very often people are concerned because of fear of technology. That's one. Secondly, security is another. So we just need to explain to them that it is a secure process and what is it that we're doing to help secure that process. So in mediation, to answer the question, we would not force parties if they really do not want to mediate online, because it's just not going to start. It's not going to work out well. And if it is a arbitration situation, if they don't want to do the mediation, then the matter will be referred back to arbitration, and arbitration will continue. So it will not be delayed. It cannot be used as a delaying tactic, because in our up protocol, there's only an 8-week window where the arbitration is put on a pause. And if the parties cannot agree within that 8 weeks, then they go back to arbitration. So, but my own experience is that once the parties understand why online is good, they would normally not have a problem. Thank you.
Okay, thank you very much. We have another question about is what will be the future of the mediation in 10 years? But there's one more broad question. I'll reserve it for a moment. But there's a more specific question in connection with investor-state dispute. So will state or investors be more inclined to use mediation and exit ISDS going forward? Particularly, there will be big flood of investors' claims. What do you think about that idea? Meng?
So I thought, maybe George, why don't you go ahead? You're off mute now.
George, yeah.
Shall I answer, Kevin?
Yes, please.
Yes.
Okay, because I've been attending the sessions at Working Group 3 in Ancitral, and I would say the answer generally is yes. And this is the reason. In fact, one of the African countries, the representative said, we have an investor claim for $9 billion US dollars. And they said, if we fail, if we lose, it's going to affect our whole economy. Okay, and the statistics are, at the moment, according to one party that stood up, parties which can afford to have top 10 global law firms in arbitration represent them. The statistics are that you are more likely to win at an arbitration. Okay, I mean, you have to measure that yourself and see whether you agree with it. But if that is the case, this becomes very important because it can actually affect many countries. And that's why 107 states are represented at the working group, which is a record. There's a lot of interest because if you're a country and you want to invite investors, what happens when the investor has a dispute with you? And now you know there's a complication because of third-party funding. Many of the cases, investor-state disputes are funded by third parties. I mean, this is happening now. Okay, so there is this balance which needs to be achieved. And I think there is a recognition now that if you can mediate the dispute early, I mean, I have done an investor-state dispute, okay? And I can tell you from experience that if it's done early with a chance of salvaging the relationship between the investor and the state, it's so much better. The problem now is that it comes too late. That's why many of the disputes cannot be resolved. So I think there's a realization that mediation can play a more important role. And I foresee that this will become an increasingly important area. And Korean lawyers, specialists in investor-state disputes, I think you've got to get into the scene. Okay, have mediation skills as well as arbitration skills.
Okay, thank you, George. Actually, already have about 10 minutes past from original time plan. As you see, we just started on time, and every panelist actually really get the right time. Then you have an idea how we operate mediation and SIMC and KCAB. So you expect like this time, very efficient handling of the case. We're always thinking about more efficient dispute resolution using the benefit of mediation. So that the broad question, what will be happening in 10 years in international mediation? I would say we will see much more mediation in a bigger dispute. And my personal experience is for the last 3 years, with there's several arbitration I've been involved, turned to the mediation in the middle of the arbitration. The case was settled, or some case was not settled, but went back to the arbitration, but it saved a lot of issues, or the parties come to a settlement at the end. So I will see that including investment treaty arbitration or dispute, we will see more international mediation and in every jurisdiction. Particularly, as George mentioned, that the 4 factories, so India, China, Japan, and Korea, together with Singapore, with the help of Singapore Convention, I would expect that we will see a lot of mediation proceedings and significant development in the mediation, together with international arbitration in the region. So let me thank again SIMC and the KCAB for organizing this conference, and that many people actually work behind the scene as they have an opportunity to actually show their face. But it's a wonderful assistance and arrangement. Special thanks to Professor Shin to make this possible, and all the panelists, and particularly special to all the participants. I saw that we have up to almost 80 participants at the highest number. So thank you very much. And I hope everybody have a wonderful time. Thank you very much.
Thank you.